This is Attorney Shah Peerally, and we are going to talk about another memo, of course, another one which is basically kind of going to create a lot of issues and even possibly self-deportation for many of the immigrants, legal immigrants. Before I start, this is Attorney Shah Peerally from the Shah Peerally Law Group, and we deal with immigration law and also debt settlement, but we are going to focus on immigration law here, and we're going to talk about this another new memo that just came out, basically saying that they will now, basically, if you look at it, here it is, the USCIS will actually, at their discretion, deny cases without even having to send an RFE or a notice of intent to deny. This is very worrisome, again, because the problem is that it doesn't give you an opportunity to answer, and it's like just not having your day in court, as we call it. And this is getting more and more difficult on people. If you look at, here's a memo, and effective date will be September 11 and will apply to all petitions. What happens is that, let's say you file a petition and something is missing, or some kind of clarifications is required, USCIS usually will send an RFE, and that was the policy under Obama, the RFE or notice of intent to deny, to give you a chance to answer. But now what they're going to do, they are just going to take on themselves and deny the case, stating that, hey, you didn't provide enough information. So guess what? The next step will be either to refile or ultimately to go back home. The problem now is we have this other memo, and now I will go back here. This is there's another memo which I spoke about, which is a notice of intent to appear. That memo basically says if you get a denial on anything, right, doesn't have to be an extension. For example, you are denied, you pass your date on the visitor visa, you get put into deportation. Now, with those two memos combined, one denying, not giving a chance to people to answer, and also the second memo, the memo which was passed before that one, where they would put you in deportation, we're going to see some really, really difficult times for people. That means you won't even have time to pretty much pack up, and that's where it gets tricky. The question everybody's asking, how much time will they give people to leave? We are hoping at least 30 days, but there's no guarantee on that. It can happen within days. So the problem is that once you're placed in deportation, you will have to get the permission of the judge to go back. And if you don't, you will be placed, if you just leave like that, there's a chance you will never be able to come back, because you will be in a deportation stage, which carries a mandatory bar of 10 years. So all those memos, when you combine them, we saw a flow of memos from the student visas and up, including those who get out of status, basically cancelling the DS, possibly not cancelling, but making the DS works differently, the duration of stay for F1, combined with this memo now with no intent of notice of intent to deny, and combined with the deportation order that will be placed on people, we're going to see, it's like a domino effect now. One will lead to the other. So we are telling people to be very cautious when they're filing their cases now. Make sure all the paperwork are done properly, number one. And number two, we also recommend that quickly, if you want to refile, but leave the country as soon as possible. Like I said before, I was recommending to stay a little bit, but now I don't. I recommend that you quickly leave the country also. And that's the previous memo that we were talking about, that is the cases of referral to notice of intent to appear in court, where basically you will have to you will be placed on deportation, and you have to fight your case there. And of course, that's a lot of more complications on your head. But now the memo I was talking about today is this memo, where basically they will deny cases without giving an RFE or a notice of intent to deny. It used to be, like I said, and they amended that now in their manual, that they will not issue an RFE if they don't want to, quote unquote. Then they will just suddenly send you a denial, because they believe that it's their discretionary power to do so. The question, will we attack this in a court of law? That's a different issue, because not giving a chance for an RFE or notice of intent to deny, according to me, amounts to not giving a chance to answer and basically it's kind of a violation of the Fifth Amendment. I think so, but I'm not sure. I have to double check on that because this came to right now, and because you have to have an opportunity to defend yourself, and without the RFE and the notice of intent to deny, we don't know really what's their reasoning behind the denial, and you'll get suddenly a denial, and you will have to either file a motion to reopen, which is not a good idea, or refile. And while you're refiling, if you stay here, you might be placed in deportation. So all these are going to create a lot of problems, and I am seeing people who are trying to almost self-deport themselves now, and this is going to have an economic impact, especially in the Bay Area. It might even have the house market crash because most of the people who bought houses are on the H-1B visas, etc. So this is a memo on the new. Well, I'll just repeat that. This is a memo that just came out yesterday on July 13th. Well, today actually, when I'm doing this video, and it's an issuance of certain RFEs and NOIDs, and this is going to create a lot of havoc. So anyway, this is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Feel free to reach out to our office 510-742-5887, or just check our website attorneyonair.com. Thank you.